Hello, my name is Douglas Caddy. I'm your host tonight on this public affairs program from Houston Media Source. Our topic tonight is what you should know if you are ever arrested. We originally had planned to have the chief of the felony trial division of the public defender's office as our guest, but he called me to tell me that he was in the hospital. He had broken his ankle. But we are very fortunate to have with us an assistant public defender who has tremendous credentials, as you'll find out, who will take the place of Eric Davis. And her name is Betsy Stukes Martinez. And Betsy is going to lead us through the criminal procedure that you should be aware of if you're ever arrested for any cause whatsoever. And so tonight, I'm going to essentially turn the program over to Betsy Stukes Martinez, who told me just before we started the program that she teaches a course on criminal law in law school. Is that right? In law school?
Undergraduate.
Actually. Undergraduate. So essentially, she's going to give us a course tonight on criminal procedure that will assist you in gathering information in case you're ever arrested. So take it away, Betsy Stukes Martinez.
Well, thank you so much for having me. And, please feel free to interrupt me. I'd hate to just lecture at everyone. So ask as many questions as you can think of. But thank you so much for having me. And yeah, I'll just jump right in. So I work for the Public Defender's Office in the Trial Division. We handle all felonies in our division, which ranges everything from small drug cases all the way up to murder cases. And I've been there now for about 1.5 years. I've been a defense attorney my entire career in criminal law for about 7 years now, which is hard to wrap my mind around sometimes, but it's been a great experience. I love my job, but I want to tell people, I think it's very important that people know the basics. I think there's a lot of misperception about what happens if you get arrested or how you can get arrested. And so I'm really glad to be able to just try to clear some of that up so that people know what to expect or how to prepare, even though there's not much anybody can do to really prepare for that. But we're going to talk a little bit about what will happen and, things you can think about if that situation ever arises for you or for a loved one. So first, let's talk about how you can get arrested. Now, there's a lot of different things that could happen or things that you could be accused of lead to a criminal charge. But there's a few ways that they'll practically show up. So a lot of cases start with a traffic stop. And what do I mean by that is exactly what you think. You're driving down the road, someone pulls you over for speeding or failure to signal a lane change or failure to put on your blinker when you're turning left. Something very simple can turn into a lot worse problem if things go awry. So in that situation, what are some things that people can think of, right? So first of all, I always think it's important to let the officer tell you what they stopped you for. So I think actually my husband and I were driving to the Hill Country recently and got stopped for speeding. And the officer really wanted us to tell him what we thought that we did wrong. And that's not our job, right? That's the officer's job, is to know what we did wrong. And yes, it's not just a principled point. It's also because the reason for the stop is very important to any criminal case that might arise from a traffic stop. And why I say that is because if they did not have a legitimate reason to stop you, and they stopped you for, you looked out of place, or they thought your car looked fancy and you weren't driving in a nice area or something like that, they also have to have some legal reason to stop you. Now, I don't know when's the last time you looked at the traffic laws in Texas, but they are extensive. So there are a lot of ways that a cop can pull you over, and it's very much legitimate. But it's important to me for the cop to tell you, because if you tell them, you're essentially admitting, oh, I think I was speeding, or, oh, I think I didn't have my headlights on, or something like that. So that's one thing to think about right off the bat. Make sure that they're telling you why you got pulled over. And of course, no need to be rude about it. It's just a simple question, and there's nothing wrong with asking it. But that is a big deal. So, all right. So let's say you got pulled over. The officer tells you it's for speeding. What rights do you have at that exact moment? You do have to give him or her your insurance, and you have to identify who you are, probably by way of a driver's license. And the officer takes that back. I mean, we've probably all been through this. They can take their time looking up your name, make sure your insurance is good. They can, they'll look and see if you have warrants out for whatever reason, traffic or otherwise. And they can do several things to make sure the car isn't stolen. There's a few things that are legitimate parts of a traffic stop that they can choose to do. One important thing to remember, though, is that the law is very clear that an officer cannot extend the time of a traffic stop more than what is necessary to execute those essential functions of the traffic stop. Now, what that means in reality is a little bit more wishy-washy than defense attorneys would hope, but it does have limitations, and it does put a stop to them holding you on the side of the road for 3 hours while they wait on the drug dogs to get there, or while they wait on an officer who knows how to do driving while intoxicated testing. They can't do that. They can't just hold you there without some reason to extend the stop. There are reasons to extend a stop, obviously, that can meet legal muster, but there are a lot of limitations on that. So something to be aware of. All right, so let's say you get through the traffic stop, and the officer thinks, nothing's wrong, but I feel like something's fishy here. They may ask you, can I search your car? And there are a lot of laws that protect people against searches of their stuff or searches of their home. And those things protect you so much unless and until you consent. So what I mean by that is saying, if an officer says, can I look through your car a little bit? And you say, yes, that's enough. They can go through the whole thing. I think one common misconception about that is that, oh no, they can't go through the trunk, or they can't go through a backpack, or they can't look in the glove compartment. Those things are generally wrong. That's a misperception of what cops can do if they have consent. If you give a general consent to search your car, that's going to include pretty much anything in there. So be careful about that. I mean, if you even have a worry in the world, it is absolutely your right to say, no, I don't consent. I do not consent. There's nothing wrong with that. And there's nothing legally that they can use against you for you refusing to consent. That's why we have the Constitution. We have all sorts of protections for that moment. And I think for most people, it feels weird, right? It feels wrong. It feels like, oh, I'm going to look sketchy if I don't consent to this. But it's a lot better to look sketchy than to end up in jail. So be really careful about when you consent to things. And then let's say, you're in a car and your friend consents or something like that. And you think, oh, I listened to this girl on, the TV, and she said, don't consent if you don't want to consent. You can always take it back. So you have to be very clear in that. You have to say, I'm taking back my consent, and you no longer have my permission to search this car, or whatever they're trying to search. And that is legally sufficient to end that search, unless the police officer has developed independent reason to search the car. So the most common of that we see is the smell of marijuana. It's common for a variety of reasons that you can imagine, but one of them, at least from a defense perspective, is it's almost impossible to prove that a cop did not smell marijuana, right? Or smell anything. It's hard to prove someone didn't smell something. So that's a very common way that officers are allowed to search entire cars. So be really careful about that and be wary of who's in your car. Because if a person smells like marijuana in your car, it's going to give a police officer reason to search everything in it, whether it belongs to your friend or not. And that puts everyone at risk. So be really careful. And I say that's the most common, or one of the most common reasons we see for a search without the person's consent, but there are plenty of others, right? So if they see something in the car that looks like drug paraphernalia, that might be part of it. There's a lot of different things. So, be careful about that. So let's say they do conduct a search and they find something illegal in the car, drugs, a weapon, a variety of things that can be found in cars, I have learned through my years. And then they have a situation, right? So what happens then? Probably you're going in handcuffs. Sometimes we see people saying, this isn't mine, right? This is somebody else's in the car, but I was the driver. Now, protections there. It's not automatic that if you were the owner of the car, you necessarily had possession of that drug or whatever it is. But it's hard. It's something that you'll probably have to fight in a courtroom, and you're probably not going to win on the side of the road during a traffic stop. And what I mean by that is if your friend has a baggie of, marijuana in Harris County, now it's changed a little bit. Let's say if your friend has a baggie of cocaine or something like that, and it's on the floorboard, and it's closer to them than it is to you, but it's still in the car, you very well might both get arrested. And that is fair game, at least in the beginning. Now, like I said, there are some protections. It doesn't necessarily mean you're legally in possession of that cocaine just because it was in your car, but it's a tough thing to argue. And so again, I just, be wary of who's there and what they have. And I know that it's impossible to know if someone comes into your car and just doesn't mention it. But it's something to think about. Okay, so let's say they find the cocaine. Now what? And let's say the cop decides, I'm going to arrest both of these people in the car. Put you in handcuffs, put you in the back of the police car, might call a backup police officer to take you both separately. And they may try to ask you questions. So this is another big protection that the United States Constitution and the Texas Constitution gives people. And I don't take those things lightly at all, and I don't think you should. But you hear a lot about Miranda rights, right? Nobody read me my Miranda rights, and so, that's it. So let's talk a little bit about what are Miranda rights. So Miranda rights, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney, and if you can't afford one, the court will appoint you one. So everyone's heard that in movies, right? And you think, oh, they have to do that. They have to do that absolutely every time they come in contact with someone. That's the rule. Turns out that's not the rule. So what the rule actually is that if they want to use what you say and you are in custody and you are being interrogated, and I can talk, that's a lot longer conversation that I won't get into, then they must read your Miranda rights. But if they're just talking to you at the traffic stop, or if you're sitting in the back of the cop car in handcuffs, you're clearly in custody, but you just start blabbing, all of that is still probably going to be used against you. And so you have to be careful about that. Don't hang your hat on, oh, they didn't read me my Miranda rights. And I'll also tell you, most people are afraid in that moment, right? They have fear, they have worries, they're thinking about who's counting on them coming home for dinner or whatnot, picking up the kids. And so they almost blank about whether or not Miranda rights were read. And so I do end up sometimes with clients who think that they weren't read their Miranda rights and think that's going to be the solution to the whole case, and it's just not. So don't hang your hat on that. But it is an important protection, because if you're in custody and you're being interrogated or asked questions, then they must read your Miranda rights. Now, if they don't, what does that mean? The only thing that it means is they can't use anything you say, or something that comes from what you say. But it doesn't necessarily mean that that baggie of cocaine is out the window. It probably doesn't mean that. So it doesn't fix whole cases all the time. Sometimes it's really important. If they don't read their Miranda rights and someone confesses or something like that, that can be extremely important in a criminal case. But it's not always as powerful as people think it's going to be, unfortunately. Okay, so that's a traffic stop. That's one way that they can arrest you right then and there, right? They found the cocaine right then and there. There's no formal arrest warrant yet. You don't have a warrant for that. You've heard that, I'm sure. There's no formal arrest warrant, but they have the probable cause, is the legal term. They have the probable cause to arrest you. And so at least here in Harris County, and other counties too, but everywhere operates a little bit differently. And I only practice in Harris County now. I've practiced elsewhere before. But here in Harris County, it's pretty quick in terms of how they get you charged. So let's say they find the cocaine baggie, put you in handcuffs, put you in the back of the car. Then they'll call the district attorney's office, also known as prosecutors, and they'll say, here's what happened. Stopped him because he was speeding, searched the car with his consent, found a baggie of cocaine. Do you want to press charges? And the district attorney will say, yes, I want to file charges. And so then you're arrested, you're taken downtown. So I do want to pause on that note. What is downtown, right? We hear, oh, take him downtown all the time. What does that mean? Now in Houston, we have a centralized place. We used to have a bunch of different smaller police offices that you might get taken to first and get processed and then brought down to the main jails. Now everyone is supposed to go to this one place. It's called the Joint Processing Center. It's downtown. It's the newest of the jail buildings. I still don't recommend a tour, but it's nicer than the rest. You go in there, everyone's in one humongous room, and you end up waiting is what happens. You get down there, and the purpose of putting it all in one place was to speed things up with processing and getting people out. But, it has in a lot of ways. It's worked brilliantly in a lot of ways. But some clients will complain because it used to be you did all the hard work when you were at these smaller substations, and by the time you got downtown, it was quick. Now it's not that way. Now you get downtown, you may be there for more than a day, really. But in that time, our office actually has attorneys that work there as defense attorneys, and they represent every person in there who wants them to represent them for free. And they represent them for the purpose of bond or bail, you might have heard. So let's talk about that a little bit. What is bail or bond, right? So when someone gets arrested, what we call a magistrate judge sees them in the jail. So if you've known anybody who's been arrested before and seen a TV judge, that's who it is, because they used to be on TV and you just see them on the TV. Now you'll see them in a courtroom, but sometimes still the TV. So you go into this courtroom, and the only thing they're there to decide is, was there enough to arrest you? And that's not to say you're guilty. Was there enough to arrest you is a very, very low standard. By the time you get to a trial and say somebody is guilty or not guilty, it's a lot higher standard, that you need a lot more proof for the trial than you do to arrest someone. And that makes sense, right? You arrest them, and sometimes you have to sort out the details. But at that court, they decide, did they have enough evidence to arrest this person? And should they get a bail? And if they should get a bail, how much should that cost? There's been a lot of talk about that. I don't know if that's been on this show before, but there's been a whole lawsuit in Harris County because it was a class action lawsuit, meaning a whole bunch of people got together and sued for the same thing. They basically said, Harris County, you're doing things that are contrary to the Constitution because you're holding people who don't have money in jail and you're letting people with money go. And they may be charged with the exact same thing. They may be exactly similarly situated. The only difference is one person has money and one person doesn't. And part of the argument was just because someone can pay money doesn't necessarily mean the community is safer, right? There's nothing about someone with $10,000 in their back pocket that necessarily makes them a safer human being. But that was the only difference. And one person would get to go free and fight their case, and the other person would have to stay in jail. Well, one lawsuit has come to a settlement, and basically the what I would call the good guys, because I'm a defense attorney, but the good guys won. And now there's a lot of changes in place about protections for people, that we're not supposed to be differentiating people just based on their income level or their ability to pay. So that helps in a lot of ways. It's certainly not perfect, and I'm not going to tell you it is. But I guess if we're talking about basics, some people ask, how much is a bail? How much is a bond? And how do you even do it? And that's a great question. It's more complicated than I can even say, but I'm going to simplify it down. And the answer is, so for a misdemeanor charge, because of the lawsuit I was just talking about, a lot of those bonds will be what we call PR bonds, or personal recognizance. And what does that mean is it's free. It basically means we're going to set an amount. We'll say your bond is $500, but it's a personal bond. So you don't have to pay any money up front. But if you miss court, then you would technically owe us the money that you didn't do what you said you were going to do, which is come to court. And so you owe us the money. But the good news is that means people are getting out initially for free. Well, I guess I say this, all of this is in the lens of a criminal defense attorney, of course, but that's who I am. So that's how I'm going to talk. So on a misdemeanor, a lot of times people will get out for free. If it's not something for free, it's normally going to be less than $5,000. Every once in a while, there's something that comes up that will be more, but it would have to be pretty extenuating circumstances if it was a misdemeanor. And I'll talk about what a misdemeanor is here in a second. If it's a more serious charge or a felony, there is a lawsuit that's happening with those along the same lines of what I talked about, but it hasn't actually gone through the process yet. So those are definitely more expensive bonds. It could be something relatively inexpensive. There still are personal bonds for felony offenses sometimes if the judge wants to give it to you. But generally speaking, you're going to pay more if it's a more serious offense. So if it's a very, very serious case, you might see hundreds of thousands of dollars of bonds. Let's say it's a murder case. It might be $200,000 bond. But if it's a smaller drug case or something like one baggie of cocaine, it might be a personal bond. It might be something like a $2,000, $5,000 bond, something like that. Now, this is definitely a Harris County. I'm speaking about Harris County, Houston. In other counties, particularly smaller counties and more rural counties, it all gets worse in terms of getting out on bond. It all gets more expensive. It's a lot harder for me to say exactly what it would cost in other counties. So take it with a grain of salt. But a lot of times in the middle, if it's something not so serious, but also not the most serious, you'll end up with $10,000 or $15,000 or $20,000 bond. And sometimes people hear that and they think, oh, like who has $20,000 sitting around, right? And most people don't. I mean, lucky you if you do. I'm very happy for you. But typically, people don't have that kind of cash. If you have the cash, you can pay it all up front. And as long as that person makes it to court, you would get it back at the end of the case once it's completely done, which is great if you have the cash on hand. But what happens if you don't have the cash? Most people have to go through a bonding agency or a bondsman, and there's a bunch of different ones. They're private businesses, so they do this for profit, but they will help you. And essentially what they do is you pay them a percentage of whatever the bond was. It used to be 10%. Now there's different things happening for a variety of reasons. So sometimes it's less than that, sometimes it's more than that. But usually it's 10%, or it used to be at least 10% of whatever your bond is, right? So that's a lot more affordable for most people. It's a lot more doable. So most people will go to a bondsman and say, hey, can you help me? They pay the 10%. The bondsman goes to the jail. They pay the rest of the bond with their mechanisms, and then the person gets out. So that's bail or bond in a nutshell. So if you're able to afford your bond or you can get out, you get out and live your life. Now you're on bond is what we call that. You're on bond. And what that means is that courts can put different requirements on you. So it might just be something simple, like you have to stay away from drugs and alcohol. And well, simpler for some than others, I guess, but it might be something kind of basic like that, where they can drug test you all the time, but they're not going to drug test you every time. And, you need to follow that rule. Sometimes it gets more complicated, right? So if there's a victim, or what we call a complainant, in the case. So if it's something like an assault family violence, where someone's accused of hurting their, let's say it's a girlfriend in some cases, the conditions of your bond are probably going to say you have to stay away from that person, that complainant or that victim. There's also more complicated ones. If it's a more serious charge, you might see something like a GPS monitor. Those are very expensive, hundreds of dollars every month, unless you're indigent, and then, the court can help you pay for it. But they're very expensive, and they do what you think they're going to do. They track your location. You wear it as an ankle monitor. If you ever seen Lindsay Lohan, she had one for a little while. And it's meant to keep track of where you are, and make sure you don't flee, right? And so, but it can also do other things, like they could put a curfew on you where you're only allowed to leave the house from 9 to 5. And after that, you have to be home, or else it's going to send an alert to the court where they might issue another arrest warrant because you didn't follow the rules of your bond. So bond can be very complicated. I think sometimes people perceive it as getting off easy, right? They think, oh, these people, they committed these horrible things and then they just get out and live their lives. But it is not that simple. Most of the time, especially if it's a serious offense that you're charged with, bond conditions can be very, very strenuous. They can put a big limitation on not just fun things, but things like picking up your kids from the daycare or getting a job that has strange hours. Now, judges can adjust those rules, and a lot of the judges now that we have are understanding about if you have a job that's, let's say, an overnight shift or something, they'll shift your curfew to be overnight, which is helpful for the job, but terrible for everything else, because if you needed to go to the grocery store one day, you're going to have to do it at 6 a.m. when you got out of work at 5 a.m. after working, 10 hours or something. But there is some flexibility. It's just up to the judge. The judge gets to decide, do they want to allow it or not? So that's bail in a nutshell. There's a lot more to it. But otherwise, if you can't afford bail, which a lot of my clients cannot because I work for the public defender's office and we categorically represent indigent clients, then you stay in jail for as long as your case is pending. And so I mentioned that there's a difference between misdemeanors and felonies, right? So misdemeanors, generally speaking, are just the less serious offenses. So your first driving while intoxicated, a regular assault, like no one got super, super hurt, but there was pain involved and someone caused it. Marijuana charges are misdemeanors generally, unless it's a lot of marijuana. So there's less serious charges. There's also some that you may consider very serious, like assault family violence. Your very first assault family violence case is still a misdemeanor here in Texas, depending on the circumstances, but normally it's a misdemeanor. Felonies are more serious, but like I said, there's a wide range of felonies. So we can go all the way from one baggie of cocaine all the way up to murder. And those are all felonies, technically. They're different levels of felonies, and so different levels of punishment for each, but felonies nonetheless. And I don't know how many job applications you've filled out lately, probably not too many, but there are, almost every job will ask you, have you ever been convicted of a felony? And that can put a huge damper on a person's life if they get convicted of one felony, even if it's one of the less serious ones, because it's still technically a felony. So that's a really big deal. It's something that people should really think about if they ever find themselves in trouble, is do I really want to plead guilty to a felony? Because it will change your life. It's not just jobs. It's also housing. Sometimes getting loans can be affected, including student loans. All sorts of things come with getting a felony conviction. All right. So I've spent a lot of time on the early stages. But so once you get out, let's say, what happens in the courtroom? A lot of people think their very first time they show up to court, when you get a court date, that's going to be their trial. Because that's what it's in every movie, every TV show. You show up and that's your trial, and everybody's ready somehow, and every witness is there, and everybody's in the know. Well, unfortunately, that is not reality at all. Your first several court appearances probably are going to be nothing more than collecting evidence from the prosecutors and negotiating and figuring it out, right? You still, as a defense attorney, there's a lot of investigation that happens, right? We can't just take what the police say and that's it. Sometimes what the police say is exactly what happened. It's exactly right. Sometimes it's absolutely the opposite happened, or it's missing a critical detail, or sometimes it wasn't even your client. Maybe it was somebody else and the police mistook the wrong person. So there's a lot of investigation, and so that takes time. You've got to locate witnesses, you've got to get records as an attorney. And sometimes I think for person accused, that can feel like it's just dragging on forever, because the perception is I get charged, I get justice, and it's over. And that's hopefully what will happen, but it takes a lot longer than most people think. So there's no exact number, and COVID has definitely slowed everything down. But misdemeanors, I would say 6 to 9 months is not an unusual number to see if the person's on bond. They can absolutely end sooner, no doubt about it. If it's a simple case, which most cases that people say are simple turn out not to be simple. But if it is something easily solvable, at least sort of kind of easily solvable, it can absolutely end earlier. But it's not unusual for a misdemeanor to take 6 to 9 months to resolve completely, whatever that may mean. Felonies, much longer. Again, they can always end quicker, but if you have a good attorney who's doing a good job and getting what they need and doing the investigations they need to do, it's absolutely not unheard of to be going through the court system for more than a year. And normally when there's no COVID, which I know that's just disrupted everything, but the courts are a completely different place now. Normally you would have to appear in the courtroom, show up on time, and be there with your attorney about once a month. Now with COVID, most things have turned into Zoom court. And so occasionally people have to show up in real life, but they're really trying to limit the number of people in the courthouse. So it's a little different now. But like I said, with felonies, it is very, very common for it to take a year or more, just to get everything you need done. Okay, so those court appearances, what do they look like? Typically, and I'm going to talk about non-COVID times because that's more interesting probably, but typically, if you're a client, if you are accused of something, you go and you sit in these uncomfortable benches that look like church pews, but are not as peaceful, and you wait. And the judge may take a little bit to get there, and your attorney may take a little bit to get there because they might have more than one court to go to that morning. But when your attorney gets there, your attorney will talk to the prosecutor or the district attorney. You can use them interchangeably in state court. And what they're talking about can be a lot of different things, right? So sometimes we're in a situation where it's not our client, or they didn't do what they're accused of doing. In that situation, the negotiation might be just trying to convince the prosecutor that it was not, you got the wrong guy. But I think a lot of people hear defense attorney and think that's what we're always trying to do. If the person is innocent, of course, that is what we are trying to do, no doubt about it. But there are definitely instances, and it's not uncommon, where you're in a situation that you're not necessarily in it for a dismissal, which would be dropping the case. You're more trying to mitigate damage. And what do I mean by that is that you're negotiating a plea bargain. And so that can mean a lot of different things. It could mean, if you're in felony world, it could mean prison time, or it could mean a probation. If you're in misdemeanor world, you're talking about county jail, which is the local jail, or probation. And there's other variants of things you can negotiate for, but that's your attorney's job. They go in, they talk to the prosecutor on your behalf and try to advocate for you in every way that they can think of. And ultimately, it is the client's decision, and only the client's decision, whether they want to plead guilty or whether they want a trial. Now, sometimes you get a client who doesn't want either of those things, right? They just want the case to go away. And I think in an ideal world, every case would go away very simply, but that's not as common as you think. Sometimes you're in a situation where you have to make the tough decision of, do I want to plead guilty and have an agreement as to what my punishment might be? Because then at least you have some control over the number of if it's jail time or prison time, or the length of the probation. Or do I want to fight it? And do I want to go to a trial? And they aren't exactly like you see on TV, but more like what you would see in a TV show, the trials, where we have witnesses come, defense attorneys get to cross-examine them, there's objections, there's a jury, there's all sorts of things. So that's sometimes a very, very tough decision. Sometimes you get clients who know from the get-go, I'm going to go to trial because I don't think the prosecutor's going to drop this case, but I also know that I didn't do it. And if that's the case, okay, no problem. And what's important to remember is that's always the client's decision. So I think sometimes I hear a lot after the fact, people saying, oh, my lawyer told me I had to do this, or, they made me feel like I was just going to get railroaded. And sometimes it is the attorney's job to communicate what their opinion is. But no matter what, it is that person's decision. So even if your attorney thinks you are a crazy person for wanting to go to trial, that is your right. That is in the Constitution. You get to have that trial. You get to have that day in court. And so you can choose that. So I will talk a little bit about what those things look like. So plea bargains. So let's say you agree with the state, I'm going to plead guilty to, we'll go back to our original example, possession of a controlled substance, cocaine. And the state says, okay, well, my offer is, let's say, a year in prison. In state jail is really what, we'll say. But either way, a year of time going into custody. And the defense attorney and the client can either come back and say, okay, I agree to that, or they can say, well, here's my counter offer. What about 6 months? Or what about 8 months? Or something like that, and go back and forth. And ultimately, either they come to an agreement or they don't. But if they don't come to an agreement, that's the situation where you've got to decide, do I want to take what I don't really want in this plea bargain, or do I want to go to trial and take a lot of risk at the trial because I might get more punishment, but also I might be found not guilty, and that would be the end of the case. That's a tough decision. But that's kind of what plea bargaining looks like. When someone pleads guilty, they come to the same courtroom, but it's a little bit more formal process. You go through a lot of paperwork with your defense attorney, kind of laying out what are your rights that you're giving up. So you're giving up your right to a trial when you plead guilty. You're giving up your right to cross-examine witnesses, all of those things and more. And you're doing that in exchange for this agreement that you have agreed to. And that you go through all this paperwork, Then you go in front of the judge. The judge will say something to the effect of, how do you plead to the offense of possession of a controlled substance? And you say guilty. And the judge will say, okay, are you pleading guilty because you are guilty and for no other reason? No one's forcing you to do this, basically. And you say yes, or if somebody has forced you, I hope you would speak up. But that's the time that you get to talk to the judge. It's not a long conversation most of the time. Most of the time it's very quick. They use the paperwork that you signed to prove you guilty, and that's the end of it. There's no witnesses at a plea usually. It's pretty simple in terms of how it can take 10 minutes, which is kind of shocking to some people because it's a big decision for a lot of people. And it's a big weight on someone to say, I'm guilty of a crime. But it happens relatively quickly once it's all through it, said and done. So if you go to a trial, now that's a totally different thing. Much, much longer, depending on how serious and how complicated the charge is. Trials can last one day if it's something more simple, like maybe a driving while intoxicated case where there's only a couple of witnesses. That may only last one day. If it's a murder case or something more complicated, it could last weeks. If you're O.J. Simpson, it lasted months, right? So there's a wide range of how long a trial can last, but it depends on how complicated it is, how many witnesses there are, how much evidence there is, all those things. But at a trial, the state gets to go first, and they get to say all of the things that they think prove you guilty. So they will put on witnesses like police officers. They will put on records sometimes. They'll play videos sometimes, audio recordings like 911 calls. And then after they're done, the defense gets a chance to put on their case. Now, the whole case is the state cannot prove this. We don't have to put on any witnesses because that was not enough evidence to prove anybody guilty of this. But sometimes the defense does put on their own witnesses. And so they might have their client, the person accused, get up on the stand and testify about what happened. And that's a big decision too. Also, another decision that belongs completely to the person accused. So a lawyer can tell you their opinion all day, every day, but ultimately that decision it belongs to the person accused. They can decide whether they want to testify or not. And so after all of the defense's witnesses, sometimes the state will do what we call a rebuttal case, meaning, okay, we heard what the defense says, and now we've got a little bit more to say. And if they do that, then the defense can do the same if they want. And then they do what's called closing argument, which is always the most epic part of the movie. Sometimes it's a little bit less moving in real life, but you always hope that you're as good as the movie. And then a jury gets to decide what happens. In Texas, our system's a little bit different because you call it a bifurcated trial, but really what that means is it's two parts. The first one, the only thing the jury decides is this person guilty or is this person not guilty? If they're found guilty, and only if they're found guilty, then the jury gets to decide what the punishment should be. And we have laws about that. You can't just pick any old number you want if you are at a punishment situation. But there are basically limits. There's a minimum and there's a maximum depending on how serious the offense is. And the jury can pick any number within that range. And that sounds great. And sometimes it's great, but sometimes the range is 5 to 99 years. Any first degree felony, the highest other than capital murder, is 5 to 99 years. That's a wide range, right? I mean, 5 years versus 99 years is a lifetime of difference, literally. But that's how Texas law is written. That's what the jury can do. So that kind of brings us through trial. And so I'll see, do you have any questions for me? Am I hitting the right points?
You're doing a marvelous job. If I were a first-year law student and this was my first class in criminal procedure, I'd be stunned by the amount of incredible information you're giving us. You've done a marvelous job. I just have one question, but it's say can you ask can you put into the somehow into the court record whether the police officer who arrested you has been disciplined by the police department for something in the past that would affect his credibility? Is that possible?
Sure, that's a great question. So if you plead guilty, there's not much of a record at all. And when we're talking about records, for anybody who hasn't heard it that way, it's somebody, there's a court reporter is the person that sits in the courtroom and types everything that happens at a trial, right? At a plea, they also might type it. Typically there isn't evidence outside of the paperwork that's signed at a plea. So I'm trying to think if there's a way. You could probably have a pretrial hearing about it if it was relevant in some way. At a trial, absolutely. If that police officer is going to testify against you, that is absolutely something that is important. Now, I say that there is one caveat, is the judge gets to decide whether he or she thinks that that information is relevant or not. So, for example, if the prior misstep of the police officer was excessive force, and then this case that you're accused of involves some kind of force, that's almost definitely relevant, right? This is how he acts towards people he or she arrests, and here's what happened to me. If it's something different, if it's something more discreet, like they didn't turn on their body camera one time and they got in trouble for that, and they did turn on their body camera in this case, the judge might, and it's up to the judge, it could very well come into evidence, but the judge might say that's not relevant to this case, and so we're going to not allow it. But it's a big deal. And now I'm glad that it's getting the spotlight that it deserves, police misconduct in the past now. Obviously, this has been a problem forever and ever, but it hasn't had the spotlight that it deserves. I know at our office, at the Public Defender's Office, we've started a database of public information. So that's something people might not know, is that a lot of these, not every discipline of the police officer, but things that are made public are available to anyone via a Public Information Act request. And you can look up who to contact at each agency, like HPD, Houston Police Department, or the Sheriff's Office. There's different people you have to contact, but it's public information. You just write in a request saying, I want to know all the public disciplines that this police officer has ever had. And they are required, and they're not required to send you absolutely everything, so I don't want to put it that way, but they are required to, by law, to send you things. And it may cost you a little bit of money for the copies, but if you have something that you're interested in, that is available to the public. But back to your question, yes, I think it's very important to what we call impeach or show bias in an officer, to show that they don't follow the rules themselves. They go through a lot of training about the rules of being a police officer, a lot. And if they still can't follow those rules, that's a problem. And so I think in a lot of our trials, that's something we always try to get into evidence, because we think it's important that the jury know who this police officer actually is. But it's not always allowed by the judge.
I received this newsletter from Commissioner Rodney Ellis, Harris County Commissioner Rodney Ellis, and about criminal justice reform. That was one of the pages in the bulletin that I got from him, because he's my commissioner. And one of the things he says, he proposes, is to create alternatives to arrest and incarceration for nonviolent offenses like drug possession, those suffering from mental illness, and so forth. Is this a viable alternative for being enacted, that be alternatives created for these situations?
I think absolutely yes. Some of them have been enacted. I've kind of hinted at it with smaller marijuana cases. Harris County has different policy for that. And there's some alternative punishments that are theoretically available for small drug cases and that type of thing. And I say it with that asterisk because, in my opinion, there's a lot of programs that are in place that aren't always utilized in the way that they say they're going to be. So, for example, there was a big push from the prosecutor's office for mental health patients. If somebody has a mental health issue and that's what's led to the cops being there. So for example, somebody sees somebody yelling in the middle of the street, walking down the street, they may call the cops and say, hey, something's wrong with this guy. I don't know what it is. The police show up, and the push in the DA's office, at least what they said was going to happen is, all right, let's send somebody more like a social worker, or let's have the cops bring them to a mental health hospital instead of bringing them to the jail. But I see so often that turns into something else. Like the cops try to grab the person flails, they hit the cop, now they're charged with a felony because they've assaulted a public servant. And then they end up in jail and they can't get out of jail. And so there are a lot of programs that were supposed to help, and some of them have worked and been widespread and been great. So I know that they can work, and I think people can get the help that they've needed all along in some of these programs. But my opinion is some of the programs that have gotten enacted haven't played out the way that they were supposed to, or the way that was promised. And I'm not sure exactly what the solution to that is, but I hope that there are more, because I think there are a lot of people, particularly a lot of my clients now, they're indigent. They've grown up in a world where things are different than a lot of people. Drugs might be very, very common in their area, or they may not have a house, and so they don't have any place to sleep that's not trespassing. And if we're arresting those people every single time, they're developing a long criminal history just because they're poor. And if somebody were to have stepped in and said, look, we're going to help you find a house, we're going to help you find some drug treatment if you need that, we're going to help you find a job so you don't feel like you have to sell drugs. And if they had somebody had just been there for them and started them on a better path, we might have avoided a lot of crime. But we don't have a lot of that right now, and that's really unfortunate.
Another item in Commissioner Ellis's newsletter, he says, require other officers to intervene when fellow officers are using excessive force. Of course, this goes back to what happened in Minneapolis, but based on your experience, and you were a defense attorney before you became a public defender, right? How common or uncommon is it for other officers to intervene when they see a fellow officer maybe doing something wrong in the arrest?
I've not seen it happen one time. That's what I would say. I've never seen somebody intervene and say, pull another officer off. I'm not saying it doesn't happen. I mean, I certainly haven't seen every body cam in the world. I'm sure that some officer out there has done it and is maybe watching this program, cursing my name, but I've never seen it. And I've been in practice for 7 years. I think a lot of times, and I think people can relate to it, but it turns into something more in the police agencies, is that you protect your own is one way to say it, right? You protect your coworkers. In police agencies, there's people that come up together, right? They go through the academy together. They know each other. They've been in the same car for hours and hours in the day. They care about each other. They're friends and they're colleagues. And more than just friends, they represent this entity of police officers that they want to protect. And so I think it's difficult because of the culture that's been developed. And again, it's probably not exactly the same everywhere. But my experience and my observations have been very much that there's a culture of let's protect each other. And in protecting each other, that means we don't tattletale if someone does something a little wrong, or if somebody does get shot or hurt, we back up our friend because he must have been scared or he must have felt threatened or whatnot, even if that's not really the case. The only times I really have seen it, I would say, are after the fact. So sometimes something bad will happen with police officers, and later on, there's an investigation into that act, and a colleague who was there might say, okay, I was there, it was a little much, he probably shouldn't have done that. But I've never seen somebody in the moment prevent the harm. And I think that's really regrettable because people do get really hurt. Yeah, so I think the idea to make that an actual rule is a good one.
Our guest has been Betsy Stukes Martinez, who's an assistant public defender in the public defender's office. I'm actually thrilled with the presentation you made for us on such short notice. It's been marvelous. I've learned a lot myself. I'm sure everybody else has out there. It's very logical. What you did was so logical, and everything fell in place. And I think the students in your class that you're teaching criminal procedure are most lucky to have someone like you as their teacher. So I want to thank you once again for joining us. And in closing, I want to send our best wishes to Eric Davis that he has a quick recovery because he broke his ankle, and that's not fun. I think he said it may take several months before he can get around like he used to. So on behalf of the station and myself, I thank you so much for a marvelous presentation. And I thank the chief of your division for recommending you. He certainly made a good decision. Thank you so much, and best wishes to everyone out there.
Thank you for having me.
Okay. And thank you very much. I mean, it was really terrific. Exactly what I wanted. Exactly what I wanted. People could understand, and they'll remember all this. They will remember this. So, Mark, I would like this, if possible. You did it for the first program. Can this be put up on the YouTube? I mean, because it's applicable really nationwide. I mean, there's differences between jurisdictions, of course, and so forth. Basically, the information here that we receive is applicable everywhere. And so what I'll do is work with Mark, make sure the title and make sure that you or the guest, your name and position is in there, and it will go up on YouTube.
Great.
Last time it went up there within a week. And so
parents will be thrilled.
Okay, we'll talk later. Okay,
Yeah,
thank you. Good night now. Bye now. Thank you. Can I turn off here somewhere?
I think we can take all of these.
Even